Litigation in Australia today looks nothing like it did 30 years ago. You wonder what's changed more 30 years, the law or how do we do law? In 1990s, litigation in Australia faced a serious problem: delay. Courtrooms ran on paper files, barristers waited through photocopy authorities, and adjournments were routine. Cases took years, pre-trial steps dragged on. Lawyers fought procedural battles that overshadowed the real issues. The response was a fundamental shift: active case management. Courts began to take responsibility for progress in matters, not just refereeing disputes. By the early 2000s, litigation had become so expensive that entire classes of people and businesses were effectively priced out. The law was accessible, in theory, but not in practice. In 2000, the Australian Law Reform Commission's Managing Justice Report No. 89 made 138 recommendations to make federal civil justice simpler, cheaper, and more accessible, setting the reform agenda for the next decade. States and territories then codified such overarching purpose into their respective legislations and court rules. Another key legal response is proportionality. Courts began requiring that the costs of a step must be proportional to its value to the case. Around 2010, courts across Australia began transforming into digital environments. Filing moved online, evidence moved online, courtrooms grew screens instead of shelves. From that point, law firms all adapted litigation databases, eDiscovery platforms, and document review software. Within weeks of the pandemic, Australian court pivoted to remote hearings and digital workflows. The next stage of litigation reform is already underway, and it's being led by artificial intelligence. In 2024 to 25, courts began issuing practice notes on generative AI. For example, the New South Wales Supreme Court's Practice Notes Jan 23, issued in 2025, sets explicit limits on AI-generated evidence content and requires caution, especially for submissions. But the trend of AI is unstoppable. Clear's report revealed that almost 80% of the Australian law firms had incorporated AI into its practice to some extent. Current and emerging technologies include AI-assisted document review, automated discovery relevance scoring, transcription, translation, semantic indexing, AI-supported legal research, and machine learning tools to predict costs and settlement value. But the key question is, how far can AI go in replacing legal services?